So what might happen in the case described by Frederick is that the court of one of the member states renders a judgment which determines conclusively or incidentally a question of immediate relevance to the proceedings in the court of the other member state, which is still ongoing. At least one of the parties might bring that judgment to the attention of the court and ask for it to be recognized in the ongoing procedures. And this question this raises a question which is of interest for me as a judge, which res judicata effects does a foreign judgment, which is to be recognized in accordance with the Brussels regulation, carry with it into the legal system of the recognizing state? And how should a court determine those effects? Use this now, because from Article 36(1) of the regulation, we know that the judgment given in a member state shall be recognized in the other member states without any special procedure being required. So what is to be recognized? Well, of course, it's the legal effects of the judgment. And the judgment, of course, carries with it several effects, the most obvious being the dispositive effects, creating, modifying, or extinguishing legal obligations or status. And such dispositive effects can in turn give a successful party access to state-sponsored measures for the enforcement of the legal obligation established in the judgment. And it's clear that in recognizing a foreign judgment, the recognizing member state recognizes the dispositive effects of the judgment and shall enforce them under the same conditions as the judgment given in the recognizing member state. But what about the procedural effects of the judgment, whereby the judgment precludes the relitigation of adjudicated matters, that is the res judicata effect? There is no doubt as to the fact that recognition in accordance with the Brussels regulation includes recognition of the judgment being res judicata. But the question of the precise procedural effects of the judgment in the recognizing state is less easily answered. The problem is, of course, that unlike the operative parts of the judgment, the res judicata effects cannot be found in the judgment itself, but in the legal system of the member states. And the problem is that the extent of what is res judicata and the preclusive effects it carries with it, it varies between the EU member states. A foreign judgment that is to be recognized might thus have legal effect in the states of origin that a corresponding domestic judgment does not have in the recognizing state. So the preclusive effect of a judgment typically extend to the course of action, thereby precluding the relitigation of the same claim between the same parties. The preclusive effect might be negative, preventing the admissibility of a case, or positive in the sense that the judgment shall be treated as a legal fact in a later proceeding. Sometimes the preclusive effect extends to separate issues or facts of law, including preliminary issues that are decisive for the course of action and which have been determined by the court. And in some legal systems, the preclusive effect extends only to the operative parts of the judgment, while in others it covers the necessary underpinnings for the judgment, that is the ratio decidendi. And sometimes the preclusive effects extends not only to points that have been raised by the parties in the proceedings, but also points that belongs to the subject matter of the litigation and which could have been brought before the court. So given that the res judicata effects of judgment vary between the legal systems of the member states, when asked to recognize the foreign judgments in the proceedings, there are basically two alternative approaches that the recognizing state's court can take. The foreign judgment may be given the same effects within the legal system of the recognizing state as a corresponding domestic judgment, the equalization of effects approach, or the foreign judgment can be given the same effects that the judgment would have in its own legal system. That is the effects of the legal system of the member state of origin, the extension of effects approach. And it is submitted that when dealing with recognition under the Brussels regulation, the extension of effects approach shall be the starting point of any analysis. Recognition of a foreign government or judgment is in itself presupposes the recognition of the effects that the judgments have, which of course stem from the legal system of origin. And there are expressions of this position in the United report and in the case law of the Court of Justice, for example, in Hoffman versus Krieg, Apostolides and Societe Immobiliare al Bosco. I have some quotes here, and here. Should of course be noted that the court's case law has primarily dealt with the dispositive effects of judgments and enforcement or the enforcement measures that they carry with them. And therefore, when it comes to the procedural res judicata effects of the judgments, definite conclusions from the case law cannot be drawn. However, the addition of the words "in principle," which is enshrined in several of these judgments, is important and goes to show that even if the starting point of the analysis should be the effects that the judgments have in the legal system of origin, the modification of those effects in order to adapt them to the legal system of the recognizing state should not be ruled out. In the Schlosser report, in which the effects of judgments were discussed, there seemed to be an openness for this, leaving for the courts in the recognizing member states to determine the precise effects, stating that, well, it's hard to find a general solution to the problem arising from these differences in the national legal systems. And one can also note that recognition of effects in the form of a more mixed approach, that is between the effects given by the state of origin and the effects a corresponding judgment would have in the recognizing state, is accepted in the Brussels regulations, at least when it comes to the dispositive effects of judgment and enforcement measures. So in both Apostolides and the Societe Immobiliare al Bosco, although it was stated that the recognition must in principle must have the effect in principle of conferring on a judgment the authority and effectiveness according to them in the member states in which they were delivered. The court also stated that there is, however, no reason for granting a decision when it's enforced effects that a similar decision given directly in the member states in which enforcement is sought would not have. And a similar expression of a mixed approach principle is found in Article 54.1 of the Brussels regulation, which of course concerns operative parts of a judgment. But in any way, yet another approach, of course, to the res judicata effects of member states' judgments is, of course, an alternative to applying the effects according to the state of origin or the recognizing state. And that would be an autonomous res judicata concept. And the nucleus of such a concept is found in the Brussels regulation, of course, itself, in the rules on lis pendens and the concepts of mem objecte, mem cause, as rules of lispendence are intrinsically linked to the rules of res judicata. An autonomous EU legal concept approach was devised by the court in the Gotthard case. Well, the case is well known, but to summarize, the court found that the judgment delivered in one member state declining jurisdiction on the basis of a jurisdictional clause produces preclusive effects in the other member state. And the court found that there is an autonomous res judicata concept under European Union law, and that it attaches not only to the operative parts of the judgments, but also to the ratio decidendi of that judgment, which provides the necessary underpinnings for the operative part and is inseparable for it. So this meant that not only the finding that the case was inadmissible was covered by the preclusive effect, but also that the underlying finding that the jurisdictional clause was valid and meant that the Icelandic courts had jurisdiction in the case. And as a consequence, the courts of the other member states were also obliged to decline jurisdiction and accept the jurisdictional clause as valid. So a case could be made for extending the findings of the Gotthard case to other decisions. However, there are merits in the suggestions. I think that the findings, the application should be rather limited, applicable to judgments on jurisdiction, declining jurisdiction on the basis of an application of an autonomous EU law or legal rule on jurisdiction, and where the jurisdiction of the court of origin cannot be subject to review by the recognizing states. For example, such a review that can be taken in accordance with Article 45, what is it, 1E, I think, or 3E of the Brussels regulation. And in any event, even if it would be tempting to extend the application of an autonomous EU res judicata concept to other judgments recognized according to the Brussels regulation, because that would sort of solve a problem that we can have with different understandings in the res judicata effects in the member states' legal system. Such a temptation should probably be resisted. The concept of res judicata and the preclusive effects that it carries with it have been developed within and are intrinsic parts of the legal system of each member state. They cannot be replaced by common EU rules with less than the legal systems of the EU member states be replaced by common EU law. But in any event, I would find it interesting if this question of res judicata on foreign judgments under the Brussels regulation could be lifted in the report that is to be presented, well, according to the time plan, and in Article 79 by 11th January 2022. Well, but I think we have to see about the timeline there.